You finally got your living trust set up, but if your assets are still in your personal name, your family could still end up having to go into probate court. In Indiana, that's the one mistake that can cost your loved ones months of time and potentially thousands in legal fees. So today I'm going to show you the 5 ways to properly fund your trust. I'll give you a step-by-step plan so you can actually do what works when it matters most. Hi, I'm Guy DiMartino, an Indiana trust and probate attorney and founder of Guy DiMartino Law. I get this question almost every week. I have a trust, but how do I actually put my assets into the trust? Creating the trust document is only the first step. If you don't fund it, it's like buying a safe and leaving your valuables sitting on the kitchen table for anybody to take. A trust can only protect what it owns. And in Indiana, anything left in your name at the time that you pass away can still have to go through probate if the total value is over the amount that is required for a small estate affidavit. So let's fix that. Here are the 5 ways to properly fund your Indiana Living Trust. Step 1, you want to transfer your real estate into the trust. This is the number one place to start, and it's the number one place that people make mistakes. Listing your property and address in the actual trust document does nothing to transfer ownership into the trust. In Indiana, real property has to be transferred with a properly prepared deed. The deed moves ownership from you as an individual to you as the trustee of your trust or whoever else is going to be the trustee of your trust. It must include the full name of your trust and the original date that the trust was created. And yes, the deed should be recorded with the county recorder. Technically, an unrecorded deed can be valid, but if it's not recorded, title companies and courts might not recognize the transfer. So always make sure that your deed is recorded. That way, ownership is clear and it's easy to prove to courts, banks, and the world at large. I had a client whose mom thought her home was in the trust because the address was listed in the trust document, but there was no recorded deed. We had to open a probate to get the matter resolved, the very thing that she did not want and what she wanted to avoid by setting up a trust to begin with. Have your deed prepared by someone who understands both Indiana real estate law and property tax rules so you don't lose your homestead exemption. The second step you should take in funding your trust is retitling your bank accounts and investment accounts if you want them to go into the trust. Bank accounts are usually the easiest asset to transfer, but you can't just decide that they belong to the trust. You need to contact each bank, you need to go there, and you need to retitle the account into the trust's name. Usually you'll provide them a certification of trust showing the trust's name, the date of creation, and your authority as trustee of the trust. The account title should read something like this: Guy DiMartino, trustee of the DiMartino Family Trust, dated October 25th, 2025. Your social security number stays the same. You don't have to get a separate social security number while you're alive because the trust is revocable and it is a grantor trust. A common mistake is naming the trust as a pay-on-death beneficiary because that only works after you pass away. You see, the benefit of a trust is a trust can help manage your affairs if you lose your mind, if you have a problem. So if something happens while you're alive and business needs to be taken care of and you don't have some account that's actually in the name of the trust, your successor trustee might not be able to step in immediately to take care of any business that needs to be taken care of. Investment accounts work similarly, but each brokerage has its own process. We can handle your real estate transfers, but banks and investment companies require your direct action. Make sure that this step gets done. Now on to step 3. If you have business interests or you're in any partnerships, you might want to consider transferring your interest into the trust depending upon the nature of the business. So if you own a business, you want to pay careful attention to this step. For sole proprietorship or a single member LLC, it's usually straightforward. You can transfer the membership interest into your trust. For corporations or multi-member LLCs, you need to review the bylaws of the corporation or the operating agreement for the multi-member LLCs to see what it says about transferring any type of asset into a trust. Some allow transfers to a revocable trust, others require written consent from all members. You have to look at the documents. Partnerships often have a right of first refusal or consent clauses, so make sure that you actually look at the documents before you start transferring stuff into your trust. I had a client who owned a 30% interest of a local business, and we had to get unanimous consent before transferring the shares. Wasn't a problem in this situation, but we had to jump through that hoop. So you want to check the agreements carefully before you move any business interests to avoid tax or legal problems with other people who might have an interest in the business. Now to step 4. What do you do with your stuff? What do you do with your personal property? For everyday items like furniture, jewelry, or vehicles, we use a general assignment of personal property. This document formally assigns all personal property now and in the future into your trust. You don't need to list every item. Most people do not retitle cars through the BMV, and that's fine because the general assignment will cover the cars. High-value items like art or jewelry can have separate assignments or appraisals because those are high-value items. Your pour-over will acts as a safety net, and that'll capture anything left outside the trust that you did inadvertently and pouring it over into the trust after you die. But depending upon the value of the stuff that you left outside of the trust that didn't go by beneficiary designation, it might require going into court or it might require some form of small estate affidavit before you can transfer those assets into the trust and then dispose of them by the terms of your trust. And now to step 5. And this is another very important step. You want to coordinate your beneficiary designations. This step isn't about transferring ownership, it's about coordination. Even if everything else is titled perfectly, the wrong beneficiary designation can undo your plan. Retirement accounts like 401ks and IRAs shouldn't be transferred directly into your trust. That could trigger more tax liability. Instead, you want to make sure that the beneficiary form aligns with your estate plan. You can name individuals or your trust if it includes see-through provisions in the trust for those types of accounts. Life insurance policies and annuities can name the trust as a beneficiary if you want the proceeds managed for minors, or you want the proceeds protected over time, or you want those proceeds to be available to pay for property or upkeep for houses that you might give people a life estate or the ability to live in that house for a period of time. One client had done everything right except updating a life insurance policy that still named only one son. You see, we corrected it to the trust because in the trust, the person wanted all their assets to go equally amongst their children. You see, consistency is the key. Your trust beneficiary forms and plan must work together. If there's inconsistency, that could cause problems with your family later on. Funding your living trust isn't a one and done deal. Every time you acquire a new asset, you need to decide if that should go into the trust while you're alive, or whether you want it to go into the trust by a beneficiary designation after you pass, or you want to keep it outside the trust and have it transferred by beneficiary designation. An unfunded trust cannot protect you or your family. If you'd like help reviewing your trust funding or ensuring your assets are titled correctly, call or visit GuyDiMartino.com. If this video was helpful, hit the like, subscribe, and watch our next video. Why trusts are contested and how you can prevent it. I'm Guy DiMartino. Thanks for watching, and I'll see you in the next video.